Everyone's there? Okay. I guess courtroom 2, still waiting on them. Courtroom 2, are we ready? Excellent. Mr. Haddad, can you hear me all right?
We can, Judge.
Okay. Body slowed down. This person called Mike, if the host can please place him in the waiting room until he gets out of bed and gets dressed. Otherwise, he can leave his video on. Thank you. All right, Mr. Haddad, Deputy, do we have more people coming in or should I wait?
There's only 2 officers gonna be in the courtroom, so we're not allowed to bring our people out at once.
All right, so let me just begin with this. The folks who are in the courtroom at the present time. Good morning, my name is Judge Lal, and we're going to proceed with our state all-purpose calendar with the State Court of Fulton County today, July 17th, 2025. These are misdemeanor cases in which have already been accused. First appearance has already been held for most of the cases and bonds have been set. Today, we're going to determine the status of these cases, essentially a plea and arraignment calendar. The defendant, through counsel, will advise the court as to how he or she would like to proceed. In other words, either to accept a plea offer from the prosecution and enter a plea, or enter a not guilty and have the case further notice for trial. Other matters we could address are also bond matters as well as bench warrants. Please keep in mind that if you are charged with 1 or more misdemeanor offenses, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney if you cannot afford one. One of our public defense counsel or conflict defense counsel will be representing you. So just for the record, position number 5, Fritz Breau, B-R-E-A-U, that's position number 5, is dismissed. Is that correct? Prosecution? Mr. Scirocco or someone? Ms. Folk?
Yes, Your Honor. I believe we sent that no
You have.
cross.
Yep, it's on its way. Thank you.
Okay, wonderful.
And Ms. Tucker will be addressing your matter with regards to the bond for Mr. Cox. By the meantime, who do we have?
Position number 24 and 25, Holloway.
Okay. 24 and 25. Okay. And Ms. Tucker, this is still going to be a plea?
Yes, Your Honor.
All right, thank you. Timothy Holloway is accused of affray, fighting, and public drunk back on January 4th, 2025, case number 25 CR 112B. Mr. Holloway also has a bench warrant, 25 FTA 1326 from May 14th, 2025. You've been advised of your rights and your attorney is Ms. Tucker. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Speak up, please.
Yes, ma'am, I do.
Thank you.
Thank you.
Mr. Scirocco, good morning. What's the recommendation?
Good morning, Judge. For position 24, on count 1, the affray fighting, 12 months to serve 32 days, credit for time served 16 days, and that is from January 4th of 2025 to January 6th of 2025, and then from July 5th, 2025 to present. Balance probated, complete an 8-week anger management course. No further contact with Joshua Soul. Stay away from the Exxon located at 1105 Holcomb Bridge Road in Roswell. And count 2 is 12 months probation concurrent with count 1, complete alcohol drug evaluation and any recommended treatment. And upon accepting the plea, the state will null pros position 25, the FTA in this case. Does defense stipulate the factual basis, venue, and ID for the purposes of the plea?
We do so stipulate for purposes of the plea.
Mr. Holloway, have you consumed any medicine or alcohol?
Currently, no.
And have you understood what's going on in both your cases?
Right.
Are you satisfied with your attorney?
Yes,
And are you entering this plea freely, willingly, and voluntarily?
correct.
If you decide to do so, you would have to give up your constitutional right to a trial. You won't go back to a court to face your accuser, challenge the evidence brought against you, and the prosecution won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Understood.
Was that a yes or no?
Oh, yes, ma'am. Yes.
How do you plead to one count of affray and one count of public drug?
Another.
Was a NOLO plea on the table?
It was not, Judge.
Ms. Tucker, it was either a guilty plea or a not guilty plea.
We have not had an opportunity to discuss it with the state, but is the state opposed to no low plea in this matter?
He does have a DUI conviction from 2023, so state would object here. We think this alcohol is his consumption and problems here are significant. So we're going to object to a NOLO.
I'll take a NOLO on the affray, but not on the public drunk.
Okay, just one moment. Can you mute for just one moment?
Ms. Tucker?
Yes, Your Honor, we'll proceed with entering the NOLO plea for the affray and the guilty plea for the public drunk charge.
All right. Is that how you plead, Mr. Holloway?
Yes, ma'am. Thank you.
All right. On the no contest plea on the affray, the sentence is 12 months to serve 32 days, credit for time served 16 days. Since you've completed your jail time for this case, if you have no other holds, you report to probation on Monday. I don't know what date that would be, 23rd, is that correct? No, it'll be the 21st. So it'll be Monday, July 21st, and you report there before 3 p.m. While on probation, you will complete 8 anger management classes, and you're to begin those classes within 60 days of being released. You're to have no contact with Joshua Soul, stay away from the Exxon gas station at 1105 Holcomb Bridge Road in Roswell, Georgia. For the guilty plea on the public drunk, your sentence is 12 months concurrent with count 1. And within 10 days of being released, you will submit to an alcohol and drug evaluation with any healthcare provider and submit to the treatment or counseling that's recommended by the evaluator. Your bench warrant will be dismissed. Thank you.
Your Honor, I did want to ask additionally, for the initial 2 to 3 months of probation fees to be waived. He is currently homeless and needs to obtain an ID so that he can obtain a job to pay those probation fees. So we are asking for the initial 2 or 3 months to be waived.
I will waive probation fees for July, August, and September. But he'll still need to go to a healthcare provider, Grady or any other free services for individuals who are indigent, and he'll need to do the ADET. But July, then November 1st, no, excuse me, October 1st, he will need to start paying off probation fees.
Yes, Your Honor.
Thank you.
We're gonna do position number 9, Mr. Cooper.
Okay.
You.
Come on, Cooper.
This is, excuse me, Brandon Cooper, accused of 2 counts of willful obstruction and 1 count of fair evasion, case 25 CR 3777Y. Mr. Cooper, you've been advised of your rights. Your attorney is Mr. White, and may I place you under oath for your plea? Raise your right hand. Good morning. Hello, Mr. Cooper? Okay. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Mr. Cooper, are you paying attention? Yes
Yes.
or no?
Yes.
Okay, put your hand down. Thank you. All right, Ms. Falk, what's the recommendation for these three charges?
On the willful obstruction, Your Honor, 12 months served, 30 days, credit for time served, 15 days, and balance probated, $300 fine, stay away from all MARTA. Count 2, the willful obstruction, 30 days, credit for time served, 15, concurrent with count 1. And count 3, the fare evasion, 30 days, credit for time served, 15, concurrent with count 1. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
All right, so essentially count 2 and count 3 are time served.
Correct.
Okay. Mr. White, are those the terms?
Yes, Your Honor. We just accept the plea as negotiated. We would ask to convert the $300 fine to 30 hours of community service and ask that his probation go to non-reporting upon completion of that community service.
State has no objection.
Oh, okay. It's easier. 30 hours community service. Okay. Mr. Cooper, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yeah.
Nope. Didn't hear that one.
Oh, sir.
Are you satisfied with your legal services?
Yeah. Satisfied.
Are you entering this guilty plea freely, willingly, and knowingly?
Oh, yes.
If you decide to do so, you would have to waive your right to a trial. You won't be able to confront your accuser, challenge evidence that will be brought against you in a court of law, be able to present your defenses and arguments, and the prosecutor won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 2 counts of willful obstruction of a law enforcement officer and 1 count of fare evasion?
Oh, I'm guilty. Guilty.
For count 1, it's going to be 12 months to serve 30 days, credit for time served 15 days. If you have no other cases holding you, you'll report to probation on July 21st before 3 p.m. While on probation, you will complete 30 hours of community service, and you must do this at a minimum rate of 5 hours per month at any nonprofit agency that's not a church and not a school. You're also to stay away from all MARTA property, buses, trains, and stations, in accordance with all active suspensions against you. With regards to count 2 is 30 days to serve 15 days. And for count 3 is 30 days to serve 15 days. Those are time served sentences. That's it. Thank you.
Thank you, Your Honor.
Next is number 16, Dominic Gay.
I'm sorry, there was no probation waived for him, correct?
Correct. He's doing community service. 16, 16, 16, and there we are. Mr. Dominic Gay is accused of criminal trespass at case 25 CR 3752Y from July 1st of this year. Mr. Gay, you've been advised of your rights and your attorney is Mr. White. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? It's louder?
Yes, ma'am.
Thank you. Ms. Falk?
Yes, Your Honor. The state's recommendation on the criminal trespass is 12 months, served 32 days, credit for time served 16 days from July 1st, 2025 until today. Balance probated, 40 hours of community service, BHET. Stay away from the Citgo located at 2000 Delow Drive, Southwest in Atlanta. State does not object to non-reporting once he has completed the conditions of this community service in the BHET. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
So stipulated, nothing further, Your Honor.
Mr. Gay, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
If you decide to enter this plea, you would be giving up your right to a trial. You will not be able to go back to court, have a trial before a judge or a jury, be able to confront your accuser, challenge evidence that'll be brought against you, and the prosecutor won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass?
Guilty.
Your sentence is 12 months to serve 32 days, credit for time served 16 days. You report to probation on Monday, the 21st before 3 p.m. While on probation, you will complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. You will also undergo a behavioral health evaluation, and this must be done within 60 days of being released, and you must submit yourself to any treatment that's required. At all times, you will stay away from the Citgo gas station at 2000 Delow Drive in Atlanta, Georgia. Once you have completed your 40 hours of community service, you've completed the evaluation and any treatment that's required, then your probation will be non-reporting. However, you are to always stay away from the Citgo gas station. Thank you.
Thank you, Your Honor.
Next is number 10 and 11, Cox.
So.
Your Honor, the state has had an opportunity to review the information provided by Ms. Tucker. We do not object to the bench warrant being lifted in this case, given the fact that he was in continuous custody from 11/5/2024 until May 13th, 2025, which encompassed the date of his court date that he missed.
All right. Ms. Tucker, if you will submit a proposed order just vacating and setting aside the bench warrant, reinstating his bond.
Yes, Your Honor.
All right. He's required to always keep us in the loop or contact his defense attorney if he's unfortunately detained elsewhere again immediately. And he's always to maintain a current mailing address with the court. He's also to comply with all conditions of his bond. And was there no further contact?
Let me check, Your Honor. I know there was a.
Pulling it up right now. So. Oh, well, you meant to get it faster than me.
The
There.
bond was no further contact with Kania Cheeks, stay away from her work and home address, no alcohol, drugs, weapons, or firearms.
Okay. You got that, Mr. Cox?
Yes, ma'am.
All right. Make sure that you report to Judge Besson's court for your trial. Once she finds out this bench warrant set aside, Ms. Strong, we should definitely let Judge Besson's division know that this individual is ready for trial. Thank you.
Yes, ma'am.
Number 26 and 27, Hudson.
Derico Hudson has got 1, 2, 3 charges under accusation 24 CR 820Y. They are battery, family violence, willful obstruction of a law enforcement officer, and disorderly conduct from February 16th of 2024. The second matter is a bench warrant from April 4th, 2024, 25 FTA 1327. You've been advised of your rights, and your attorney is going to be Ms. Tucker. Please raise your right hand for the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Repeat.
Yes, ma'am.
Thank you. Mr. Scarrow?
Yes, Judge, and I want to confirm with defense, this is a negotiated guilty plea, correct?
Yes.
Okay. For count 1, the battery family violence, the state's recommendation is 12 months to serve in jail, credit for time served 17 days. That is from February 17th of 2024 to February 20th of 2024, and then July 5th of 2025 to present. Count 2, which is the willful obstruction, would be 12 months probation to be served consecutive to count 1, $300 fine for him to complete FFIB, have no further contact with Liza Cruz, stay away from 236 Holly Street, Northwest Atlanta. No firearms and 40 hours of community service. And count 3 would merge with count 1. And as part of the negotiated plea, upon accepting the plea in this case, the state will null pros the failure to appear, position 27. We would sound for Miss Liza Cruz at this time, and we would ask the defense stipulate the factual basis, venue, and identification for purposes of the plea.
Ms. Tucker, do you so stipulate?
We stipulate for the purposes of the plea, Your Honor.
All right. No one has responded to Liza Cruz. Mr. Hudson, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your cases?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Has she explained to you that you would be spending up to a year in jail, and then after that you'll be released to be served another year on probation?
Hold on.
Well, there's credit for time served in this offer.
So, but I still,
It'll be 1 year less 17 days.
so I had to spend another year in jail.
Not another year. This year,
I gotta spend a year in jail.
correct. Well,
So,
the look of surprise on his face is a little perplexing. So,
I can speak with him again and we can readdress this if you'd like.
sounds good. Next case, please.
30 and 31 Johnson.
Javarius Johnson is, oh, well. Ms. Tucker, can we address Mr. Johnson and then go back to Mr. Hudson? Or do we have a case for Mr. Haddad or Mr. White? I mean, I'm sorry.
Mr. White is on the phone interviewing one of his clients.
I'm sorry. Okay. Sorry about that, Ms. Tucker. As soon as we're done, maybe you'll get a chance to speak to Mr. Hudson.
Yes.
All right. So Javarius Johnson has 2 matters before us. And case is 25 CR 552J, accused of 2 counts of battery and 1 count of willful obstruction of an officer. And he's got a bench warrant 25 FTA 132B from February 5th, 2025. Mr. Johnson, you've been advised of your rights. Your attorney is Ms. Tucker. And may I place you under oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
yes, Your Honor.
Thank you. Mr. Scaraco?
Thank you, Judge. On position 30, the first count of battery, 12 months to serve 28 days, credit for time served 14 days. That is from February 4th of this year. Or there was one date of service on February 4th of this year. And then from July 5th of 2025 to present. Balance probated, 12-week anger management course, no further contact with Zariah Woodruff. Stay away from 1492 Boulder Crest Road, Southeast Atlanta, the victim's home, and 80 hours of community service on count 2, 12 months probation concurrent with count 1 and a $300 fine. And count 3, the battery would merge with count 1. We would ask the defense stipulate the factual basis, venue, and identification for purposes of the plea. And at this time, we'd like to sound for Ms. Zariah Woodruff.
All right. Ms. Tucker, do you so stipulate?
We do so stipulate for purposes of the plea.
I don't see a Ms. Woodruff responding. Mr. Johnson, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am, I am.
If you decide to plead guilty, you would have to give up your right to a trial. You will not go back to court to face your accuser, challenge evidence brought against you, present your legal defenses and arguments, and the state won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of battery and 1 count of willful obstruction of an officer?
I plead guilty.
Count 3 battery will merge into count 1. For count,
I apologize, Judge. I should have added the state will, upon acceptance of the plea, null pros the position 31 FTA.
okay. For count 1, the sentence is going to be 12 months to serve 28 days, credit for time served 14 days. Balance will be on probation. You will report to probation on Monday, the 21st before 3 p.m. unless you have any holds. Does he have any holds? Ms. Tucker?
I don't see any holds, Judge.
Okay, then it'll be Monday, 21st at probation. While on probation, you will complete 12 anger management classes and you will enroll in those classes within 60 days of being released. You will have no contact with Zariah Woodruff. Stay away from 1492 Boulder Crest Road in Atlanta. And you will also do 80 hours of voluntary community service with any nonprofit agency that's not a church or not a school. You will complete a minimum of, this is 80 over, so about 10 hours, a minimum of 10 hours per month with any nonprofit agency, beginning with the first month. On count 2, it will be 12 months concurrent with count 1, and it will be in a $300 fine. You will pay your $300 fine at a minimum rate of $30 per month, in addition to your probation fees. Count 3 will merge with count 1. Thank you.
Number 33 and 34, Maynard.
Roderick Maynard is accused of simple battery family violence, 2 counts, from February 25th, 2025, case 25 CR 3755G. He's got a second case, 25 CR 3756G, for an additional count of simple battery family violence from July 2nd, 2025. Mr. Maynard, you have been advised of your rights. Your attorney is Ms. Tucker. And may I place you under oath?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Scirocco?
Thank you, Judge. For count 1 of 25 CR 003755G, which is position 33, on the first count, the simple battery family violence, state's recommendation here is 12 months, served 60 days, credit for time served 16 days. That is from July 2nd of this year to present. Balance probated for him to complete FFIP. No further contact with Azaria Dyson. Stay away from the apartment complex. Oh, excuse me. Let me alter that. We received information from the victim that the 1220 Gun Club Road Northwest is the defendant's mother's residence, and that the other stay away address that the state was seeking was the defendant's residence. It's my understanding the victim doesn't reside at either, so we won't be asking for stayaways.
Okay.
So no further contact with Zaria Dyson, no firearms, and count 2, that count of simple battery family violence would merge with count 1. And on 25 CR 003756G, the other simple battery family violence case, 12 months probation concurrent with 25 CR 003755G, no further contact with Azaria Dyson, and no firearms. Again, we have spoken with the victim. She does not agree with the plea offer because she wants him out to help with the children. So I will express that on her behalf. I don't believe she's able to attend Zoom, but if she was able to make it online, the state would sound for Miss Azaria Dyson at this time.
All right. Ms. Dyson, if you're on Zoom, this will be the time to unmute and start your video. All right. Ms. Tucker, do you stipulate to the factual basis, venue, and ID?
We so stipulate for the purposes of the plea. And Your Honor, we do request that he be allowed to go non-reporting upon completing all the conditions of his probation.
I will agree to non-reporting If Mr. Maynard will agree to file a legitimation action within 60 days of being released so that he can establish a solid parenting plan and child support.
So you okay with that?
But I'm listening. All right.
Yeah, so that's what.
Might get 30
Yes, Your Honor, we're agreeable with that.
So he understands that he needs to file a case within 60 days and he'll need to give the case number to his probation officer.
You have to file with the courts.
Like on court, like,
Yeah, but it's a separate court, not this one.
is it there?
No, so
I mean, long as
it's a civil.
Yeah.
Judge, while they're speaking, I do want to add one thing that the victim made us aware of after we formulated the offer and relayed that offer, was that she does want the defendant to get help with his drinking. While the state is not asking for that outright, we've already relayed the state's offer. I just wanted to make that known to the court. And we would not object to conditions that the court may impose with respect to drinking.
Oh, she's not here, so it's still no contact with her, but she can get a parenting plan and child support through a legitimation case if she wants help. Otherwise, hopefully she's opened up a case for child support services. But in
Understood,
the
Judge.
meantime, if Mr. Maynard wants non-reporting upon completion of the conditions, he needs to agree to file a separate legitimation action case with the Superior Court, in which he will need to establish that he's the father and get a court-ordered parenting plan, and also to establish child support. Is that what he's agreeing to, Ms. Tucker?
Yes, ma'am.
Okay. Mr. Maynard, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your cases?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
All right. You understand that you have 14 more days to serve at the Fulton County Jail.
Yeah.
This is 12 months to serve 60 days, credit for time served 16 days. So you have 14 more days to serve at the jail before you report to probation.
July 2nd?
Is there? Yep. That's what Mr. Scaracca said.
That's what I have, yes.
I don't have.
Are you okay? That's fine.
I mean, if y'all didn't understand that, y'all need to talk, because clearly these things come as a surprise to the defendant.
I thought the credit for time served, it was counting from July 2nd until today's date.
So that
That's-
would be 16
correct.
days. Today's the 17th. July 2nd.
So where the additional 14 days coming from?
The offer was 12 months to serve 60 days. What was the offer that you received, Ms. Tucker?
Okay, 12 months, serve 60 days, credit for 16 days.
Correct. So the sheriff gets a 2-for-1.
Mhm.
So I'm giving 2-for-1 for the 16 days, which is 32 days, which leaves a balance of 28 days. Credit 2-for-1 is 14 days.
2 more weeks. Yes, John. All right.
Not fast. Do it now.
I'll go ahead. Yes, ma'am.
All right. So, so you understand that you'll have to serve additional 14 days. Do you understand that?
Yes, ma'am.
And then you understand you'll be on probation to complete certain classes and certain requirements.
Yes.
And you have to have no contact with Azaria Dyson.
All right. Yes, ma'am.
I mean, I hope whatever I'm saying is not new to you.
I hear you, I got you. Yes, ma'am.
Okay. All right. And has your attorney explained to you that if you decide to plead guilty to these charges, you would have to give up your right to a trial? You would not be able to go back to court, face your accuser, challenge evidence brought against you, and the prosecutor won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery family violence from February 25th, 2025?
Guilty.
How do you plead to simple battery family violence from July 2nd, 2025?
Guilty.
For position number 33, count 1 is going to be 12 months to serve 60 days, credit for time served 16 days. As discussed, you have 14 more days to serve at the Fulton County Jail. Upon your release, you will report to the Fulton County Probation within 48 hours. While you're on probation,
I won't be able to.
okay, guys, I'm tired of saying things that are a big surprise to the defendant. I mean,
No, he's just saying that he has a hold in a different county. He's not
where's his other hold?
in Clayton County.
Please tell me that before we proceed, okay? Because that information isn't on the plea sheet. So where is he going to next after Clayton County?
He'll be able to report to probation.
Okay. Once he completes the 14 days at the jail, he'll report to Clayton County, or Clayton County will come pick him up. And once he gets that case resolved, and he's released, he must report to Fulton County Probation within 48 hours. Understood? Okay. While you're on Fulton County Probation, you will complete a domestic violence intervention program, and you must enroll in that program within 60 days of being released from wherever. This is a series of 26 classes, and you will attend and complete all 26 classes at your expense without missing or skipping these classes. You are to have no contact with Azaria Dyson. I know she wants contact with you, but you can establish contact with her through a third party once you file your legitimation case and establish your paternity and get a court-ordered parenting plan. So within 60 days of being released, you must also show proof that you have filed the correct legitimation case and give the case number to your probation officer. Like I said, stay 200 yards away from Azaria Dyson. Do not communicate with her in any way, form, or manner, and you're not to own or possess any firearms. For position 34, the simple battery family violence, the sentence is going to be 12 months concurrent with position number 33. Again, no contact with Azaria Dyson, and file your legitimation case within 60 days of being released. And one more condition while he's on probation. Mr. Maynard, you are not to consume any alcoholic beverages. Do you understand?
Yes, ma'am.
And we're going to subject you to random screens while you're on probation. If you fail an alcohol screen, make sure you bring your toothbrush because you'll be coming back to jail.
I understand.
All right, thank you.
Next is number 15, David Llewellyn.
This will be a negotiated plea.
Sounds good. I'm sorry, give me that position number again.
15.
15, thank you. '25 CR 3747B involves Mr. David Llewellyn, accused of 1 count of battery and 2 counts of simple battery from July 1st of this year. Mr. Llewellyn, you've been advised of your rights. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. And this is going to be Ms. Falk. Mr. White, you have clearly explained to Mr. Llewellyn there's going to be jail time, right?
Of course, Judge.
Okay, thank you. Go ahead, Ms. Falk.
Yes, Your Honor. The recommendation is 12 months served, 90 days credit for time served, 16 days from July 1st, 2025 until today, balance probated, no further contact with Charles Jacques, stay away from all Emory hospitals unless for medical treatment, BHET, and 12 weeks of anger management. Count 2, the simple battery, will merge with count 1, and count 3, the simple battery, will be 12 months served, 90 days, credit for time served, 16 days, balance probated, no further contact with Ty Thornton, and stay away from all Emory hospitals unless for medical treatment. The state would like to sound for Charles Jacques and Ty Thornton, and we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Mr. White?
We so stipulate, Judge. Just ask that the probation go to non-reporting once he completes all of his requirements.
State has no objection.
All right. Mr. Llewellyn, have you consumed any medicine or alcohol recently?
No, Your Honor.
Have you understood what's going on in your case?
Yes, Your Honor.
And are you satisfied with your attorney?
Yes, Your Honor. I just got one question.
Go ahead.
Yeah, I was just wondering, like, I don't have any holes in nothing like that, do I? I just want to make sure that when I see my probation, that I go see them. I just don't want nothing holding up.
I
Your
don't know
Honor,
what the question
check
is.
for holds.
He has a Gwinnett County hold, but he has 29 more days to do, so.
That is correct.
All right. Any other questions, Mr. Llewellyn?
No, Your Honor.
Okay. So, as I was saying, are you entering this plea freely, willingly, and voluntarily?
Yes, Your Honor.
And if you decide to do so, you would have to give up your right to a trial. You will not go back to court to face your accuser, challenge evidence that could be brought against you, present your own defenses and arguments, and the prosecutor won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to 1 count of battery, count 1, and 1 count of simple battery, count 3?
Guilty.
On count 1, your sentence is going to be 12 months to serve 90 days, correct for time served 16 days, which means you have 29 more days to serve at the Fulton County Jail, after which Gwinnett County will have to come pick you up to address that matter. Once you're released from Gwinnett County and any other holds, you shall report to Fulton County Probation within 48 hours of your release. While on probation, you will have no contact with Charles Jacques. Stay away from the Emory hospitals unless you have a verified appointment with a healthcare provider or you're seeking emergency health treatment. Within 60 days of being released, you will enroll and complete a behavioral health evaluation and submit to all treatment that's required. Within 60 days, you will also enroll in a 12-week anger management program and complete all 12 anger management classes at your expense. Count 2 simple battery will merge with count 1, and on count 3, it will be a 12-month probation concurrent with count 1 to serve 90 days, credit for time served 16 days. This time it's no contact with Ty Thornton. So this is a second victim that you would need to avoid and stay away from. Again, stay away from Emory Hospital unless seeking treatment. Thank you.
Thank you, Your Honor.
Good morning, Judge. I have position number 2, Mr. Marvin Bailey.
All right, good morning, Francois. And number 2, okay.
Your Honor, that's gonna be a negotiated plea, Judge.
Thank you, Mr. Haddad.
Uh,
All right. This is the announcement for the folks who are at ACDC. Good morning. My name is Judge Lal. We're going to be addressing each of your cases to determine the status and how you would like to proceed. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Marvin Bailey has got a bench warrant on position 2 from court April 30th, 2025, case 25 FTA 130B, excuse me. And Mr. Bailey's underlying case is 1 count of battery from February 21st, 2025, case number 25 CR 1447D. Oh, I guess I need to change my glasses. It was an FTA 001308. Sorry, Miss Greenhouse, there was no B at the end of that. Okay. So, Mr. Bailey, may I place you under oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes or no?
Yes, Your Honor.
Perfect, thank you. Ms. Folk?
Yes, Your Honor. Just to give you a little context on the battery charge, it was a battery that happened within the jail. The victim in our case is still incarcerated on pretty serious charges. So that's why we're offering a time served plea, 140 days, credit for time served 70 days from May 9th, 2025 until today. We're not asking for no further contact because once the defendant is released, he will not be able to have contact with the victim again unless he's rearrested.
Okay.
That's all for the state. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. We will be entering a null pros in the FTA.
Please stick to that, Judge.
Thank you. Mr. Bailey, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on?
Yes, Your Honor.
Are you satisfied with your attorney?
Yes, I am.
And if you decide to plead guilty to the charge of battery, you will have to give up your right to a trial. You do not go back to a court of law to face your accuser, challenge evidence that could be brought against you, present your own legal defenses and arguments, and the prosecutor won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am. I understand.
How do you plead to one count of battery?
Guilty.
Your sentence is to serve 140 days, credit for time served 70 days. So that concludes your jail time. Your bench warrant is dismissed, and you are hopefully not coming back to Fulton County Jail, even if it's to visit anyone.
Yes, ma'am.
Thank you.
Your Honor. Thank you so much.
Take care.
God bless.
Thank you.
Your Honor, for the remaining ACDC cases, Judge, I do have announcements. I will not have any pleas, but whenever the court is ready, I can make those announcements.
Go ahead.
Your Honor, on position number 22, Precious Hester, it's going to be a not guilty, Judge.
All right. Are you filing a waiver of arraignment?
I will, Judge. Yes, ma'am. Yeah,
All
yes,
right.
sorry.
Francois, is Precious Hester there?
Yes, right here, Judge.
All right. I just want Miss Hester to understand that her attorney has entered a not guilty plea on her behalf. Her case is going to be reset for jail jury trial. Thank you.
Thank you, Judge. And on position number 28, Ms. Hunt, Kiki Hunt, I'm going to reset it, requesting a reset for next week. I have to follow up on some couple of things, Judge, so I'm resetting it. I'm requesting a reset SAP calendar next week, the 24th.
All right. Miss Kiki Hunt, your attorney is asking for additional time in order to conduct further investigation. So we're going to reset your case to next Thursday, July 24th at 9 a.m.
And
Thank
Judge, lastly, number 32, Daniel Mack. I'm requesting reset for 2 weeks on him as well, Judge.
Does that bring us to August? No, July 31st.
Yes, Judge. There's other issues with him in terms of other legal matters, Judge. So this is not going to delay anything. My request on this case, Judge.
All right. Mr. Daniel Mack, for this misdemeanor case, we will address it on July 31st at 9 a.m. Thank you. Francois, do we have any more cases at ACDC?
No, that's it, Judge. Thank you.
Okay, thank you. I like your hair like that.
Thank you, Judge.
Take care. Have a good weekend.
All right, you too.
Okay.
Number 35, McCoy.
Michael McCoy is accused of willful obstruction of a law enforcement officer from May 15, 2025, case 25 SC 2703Y. Mr. McCoy, you've been advised of your rights and your attorney is Ms. Tucker. How are we proceeding on Mr. McCoy?
The negotiator.
Please? Okay. Mr. McCoy, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Scirocco?
Yes, Judge. For the willful obstruction here, it's the same recommendation that was relayed in advance of the 6/10 SAP calendar with the credit for time adjusted. It's a time served plea here, 128 days, credit for time served 64 days, and that is from May 15th of this year to present. We ask that the defense stipulate to factual basis, venue, and ID for purposes of the plea. That is all from the state.
Ms. Tucker?
We do so stipulate for the purposes of the plea.
All right, and does Mr. McCoy have any other holds? Was that a yes? Yeah, he does. Okay, thank you. Mr. McCoy, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to take this plea, you would have to give up your right to a trial. You won't be able to challenge the obstruction charge in a court of law, present your own legal defenses and arguments, face your accuser, and the prosecutor won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to willful obstruction of an officer?
Guilty.
Your sentence is to serve 128 days, credit for time served 64 days. That concludes this case. Thank you.
Position 37 and 38, Newcomb.
Brian Newcomb is accused of criminal trespass and loitering or prowling from June 24th, 2025 in case 25 CR 3760G. He's got another case for criminal trespass from July 2nd, 2025, case 25 CR 3761G. Mr. Newcomb, you've been advised of your right to remain silent, and your attorney is Mr. Tucker, Miss Tucker. All right, got it now. Okay, your attorney is Miss Tucker. Mr. Scirocco, what's the recommendation?
Yes, Judge, for 25 CR 003760G, on count one, the criminal trespass, 12 months, served 30 days, credit for time served 15 days. That is from July 3rd of this year to present, balance probated. BHET, stay away from Cheshire Bridge Apartments at 2124 Cheshire Bridge Road, Northeast Atlanta. On count two, the loiter prowl, 12 months probation concurrent with count one. No further contact with Melvin Falk, and no weapons. On the 25 CR 003761G case, also criminal trespass here, 12 months probation concurrent with 25 CR 003760G. No further contact with Yahira Ganji. Stay away from, again, Cheshire Bridge Apartments at 2124 Cheshire Bridge Road, Northeast Atlanta. And we would ask the defense stipulate to factual basis, venue, and ID for purposes of the plea, and sound for Mr. Falk and Ms. Ganji if they are online and wish to speak.
Okay, no one's responded. Mr. Scirocco, before I hand this, oh, okay. I thought that was another open case, but looks like he took a plea on that last year. Okay. Ms. Tucker, do you so stipulate?
We do so stipulate for the purposes of the plea, Your Honor.
All right. I have someone on iPhone who's trying to respond. If you'd like to start your video and audio. Okay. Mr. Newcomb, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your cases?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
If you do so, you would have to give up your right to a trial to challenge these charges in a court of law. You will not go back to a court, not confront your accusers, not be able to challenge evidence brought against you, present your own defenses and arguments, and the prosecutor won't have to prove all these charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to criminal trespass and loitering or prowling on June 24th of this year?
Guilty.
How do you plead to criminal trespass at the same location on July 2nd, 2025?
Guilty.
Do you have any reason to go back to the Cheshire Bridge Road apartments?
No, ma'am.
Remember that you said that.
Yes,
Your
ma'am.
sentence for position 37, count 1, is 12 months to serve 30 days. Credit for time served 15 days. The remainder of the time you'll be on probation. If you have no other holds, you'll report to probation on Monday, July 21st, before 3 p.m.
Yes,
While
ma'am.
on probation, within 60 days, you will enroll and undertake a behavioral health evaluation and submit yourself to any treatment or medication.
Yes, ma'am.
You are to stay 200 yards away from Cheshire Bridge Apartments at 2124 Cheshire Bridge Road in Atlanta. On count 2, it's going to be 12 months concurrent with count 1, and you're to have no contact with Melvin Falk and have no weapons and no firearms.
Yes, ma'am.
For the second case for criminal trespass, your sentence is 12 months concurrent with the sentence from position 37. Again, no contact with Yahira Ganji,
Yes, ma'am.
and stay away from the Cheshire Bridge Apartments.
Yes, ma'am.
If you return to those apartments and you're arrested again, you could jeopardize your probation in these 2 cases.
Yes, ma'am.
All right, that concludes your sentences. Thank you.
Oh, I have a question.
Okay.
I should be getting out tonight.
Within 24 hours, if you have no other holds.
Yes, ma'am.
Thank you.
Number 8, Cordell Canty,
Yes, ma'am.
going pro safety.
Did you say number 8?
Yes.
All right.
Four. Four, Your Honor.
Have a seat and please be quiet.
Yes, ma'am.
And good morning, sir. Okay. This is 25 CR 003-754J. That's your case number, Mr. Canty. And you are charged with 1 count of theft by taking and 2 counts of willful obstruction of a law enforcement officer. Incident date is July 2nd, 2025. You have a right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. Don't put your hand up until I finish talking.
Yes, ma'am.
That's why I said to be quiet. You have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you and present and help you out with their legal competent services, where they know the law and they know how to apply the law to the facts of your case. Now, if you choose to represent yourself, you are expected to know all these legal rules and the law and how they apply to the facts of your case. And if you do know the law, great for you. And if you do not, then you do it at your own jeopardy. Because if you don't understand the law and how it applies to the facts of your case, you would be legally responsible for any negative impacts that your decisions have on your case. Do you understand?
Wow.
Given this information, do you want to have appointed counsel?
Yes, I will.
All right. Ms. Tucker, Mr. Haddad, or Mr. White, have any of you spoken with him?
Judge, I'll speak to him now, Judge.
All right, thank you.
Thank you.
Deputy, next case, please.
Is Mr. McLeod logging on today? We got Mr. Hollis, and he's a conflict.
Is it Ms. McLeod?
Yes.
I don't see her on the Zoom. Miss Strong or Miss Chanel Young, have we reached out to Miss McLeod?
I will, Your Honor.
Appreciate it. Thank you. Next case, Deputy. What happened to that case with Miss Tucker, where the individual, I can't remember which position was it?
Your Honor, she's still talking to him.
She's still talking? Okay.
That's position 26, I believe, Judge.
Yes, that was the one. Okay. So, while Miss Tucker is talking and we are waiting for Miss McLeod, and we have addressed everyone else in the courtroom except for position 26. Mr. Haddad or Mr. White, can we go down the calendar, please? Oh, everybody disappeared. Is it something I said?
Mr. Haddad is speaking to Mr. Canty, so I believe the only person who may be available.
Mr.
and he
White,
may
are
be
you
speaking to
available?
someone himself.
Are they all talking? Okay, then I guess.
Yes, they all interviewing.
Okay. All right, folks, we'll be in a brief recess until our defense attorneys are ready to proceed. Thank you. Mr. White, are you done with your interview?
I am, Judge.
We can do number
Yes.
4, Mr. Mark Benz.
Okay,
This will be a negotiated plea, Judge.
thank you. State versus Mark Binns involves one count of simple battery, willful obstruction of an officer, and giving false information to a law enforcement officer from June 5th of this year, case 25 CR 3908H. Mr. Binns, you've been advised of your rights, and your attorney is Mr. White. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Fall?
Yes, Your Honor. The recommendation on the simple battery is 12 months, serve 86 days, credit for time served 43 from June 5th, 2025 until today. Balance probated, no further contact with Mary Bellino, 12 weeks of anger management, BHET, stay away from the Shell gas station at 374 Cleveland Avenue, Southwest Atlanta. Count 2, 12 months concurrent with count 1, a $300 fine, and count 3, 12 months concurrent with count 1. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. We would at this time like to sound for Mary Bellino.
Mary Bellino, are you on Zoom? Okay. Mr. White, do you so stipulate?
We do stipulate for the purpose of the plea, Judge. We just ask that the fine be converted to 30 hours of community service and ask that his probation go to non-reporting once he completes all of his requirements.
State has no, I was going to say state has no objection to the conversion of the fine to community service. I just want to take a quick look at his history. I think we will want him to remain on probation. Let me just take a quick look at his history.
Okay.
And my apologies, let me correct, it was Mallory, not Mary Bellino. Although she is not here, I just wanted to correct the record for her name for the Senate sheet. Is pretrial services available? I do not have a copy of his history readily available.
Ms. Hardy, if you could so advise.
Yes, Your Honor. Which position are we on?
We are on position number
4.
4.
Okay. Do you want me to read the whole history?
No, just the recent past, maybe last 10 years.
Okay. So there's they have 42 total cycles.
And that's all I needed to know. Thank you.
You're welcome.
So
No
the state
non-reporting.
would object to termination or non-reporting after he completes the conditions.
I'm just looking at his jailing screen. So, Mr. White, I'm agreeable to amending the fine to 30 hours of community service but given Mr. Bin's relatively healthy criminal record history, he doesn't qualify for non-reporting. He'll be required to report every month.
Okay, Judge.
All right, Mr. Binns, can't remember whether I placed him under oath. I did?
Yes, ma'am.
Okay. And Mr. Binns, have you consumed any medicine or alcohol recently?
Oh, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty to these charges, you would have to give up your right to a trial. You will not be able to go back to court to confront your accuser, challenge the evidence brought against you, and be able to, and have the prosecutor won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Are you entering your plea freely, willingly, and knowingly?
Yes, ma'am.
How do you plead? To simple battery, willful obstruction of a law enforcement officer, and giving false information to an officer?
Excuse me, I know I'll say I'm guilty, but when I had went to court, they dropped the simple battery down to simple assault.
Let's see. Which simple battery were you thinking of?
When I got arrested, when I went to court, they told me they dropped it down to simple assault when I went to court on the 30th.
I think what Mr. Binns may be referring to is this case was a transfer from the DA's office. So they did drop his charges from felonies to misdemeanors and then send it to us, and we had to accuse the case from there.
June 5th. You were arrested. You are correct, Mr. Binns. You were arrested on June 5th, and the simple battery charge appears to have been dismissed, and that left him with a simple assault charge. Did the
Yes, ma'am.
state amend it back to a simple battery?
So, Your Honor, again, I believe that was per the transfer from the DA's office.
I'm just looking at the jailing screen.
Right. So that's what I was attempting to explain. The case was transferred from the DA's office to the solicitor's office, and then we accused the case as a simple battery. So we didn't amend anything. We just accused it as a simple battery case.
I think I'm asking the very same question and you responded the same way. So in Superior Court, according to the jailing screen, the simple assault charge was the only pending charge in addition to 2 counts of giving false information and willful obstruction. These charges were then transferred to the state court, and the state solicitor's office has instead issued an accusation on that transfer, amending the simple assault to simple battery, and then keeping 1 count of willful obstruction and 1 count of giving false name.
That is correct.
Mr. White, is that your understanding?
Yes, Judge, and this is the first I've heard of it being reduced to a simple assault.
No, it wasn't reduced. There was 1 count of simple battery and simple assault in Superior Court. The simple assault was brought over and the prosecutor amended it to simple battery.
I understand, Judge.
Okay. Mr. Binns, would you like to speak with your attorney?
Yeah. Yes, ma'am.
Okay. All right, Mr. Binns, Mr. White, please explain to him why it's now a simple battery. Is anybody else ready in courtroom 2?
Yes, we can go to number 8. Can't go over there.
All right. Well, we're gonna go.
Judge,
Before we proceed with number 8, Ms. Munez is on. I'm not sure if she's a victim. She was here from Marvin Villalobos, but he's been released.
he was
Let's hold out.
Okay, Mr. Haddad, who are we addressing?
Judge, this is on position number 8, Mr. Canty. I just sent an email to Ms. Falk. If she can just respond orally is fine. And
All right, Ms. Falk, have an eyeball at that email and then see how you respond to it via email.
I
Meanwhile-
did take a look. The answer is no, based on his history.
I'll just say.
All right, please mute your screen, Mr. Haddad. Okay. Brianna Muniz, please unmute and start your video. Brianna Muniz. Phelan, please unmute and start your video.
Oh, I got a low bum. Oh, I got a low bum.
Hang on, stop talking until Mr. Okay, there we go. All right. And this person who's on iPhone, please unmute and start your video. Folks, if you don't unmute and start your video, I will remove you from Zoom. All right, this person on iPhone, what's your name?
India.
What?
India Ezard.
Dia Ezard. Have we addressed
India.
your case?
I'm here as a victim, no, victim's advocate. My case is with Zarek.
Your audio is going in and out. I can't hear you properly. Is someone doing your hair?
No.
Yes,
Yeah,
please
but
get up
I'm a
and get
victim.
out. Get out of there. I'm not going to sit there while you're doing your hair. Oh my God. This is a courtroom, not a beauty salon.
I'm the victim, so I didn't know I had to.
Okay, if you don't want to appear, that's fine. But ma'am, you're in a courtroom. Your hairdresser doesn't appear in court with you. Unless you're Beyonce getting ready for a show.
Right.
Okay. Okay.
Your Honor, this is position 23, Zarek Hollis.
Okay. Once she's done with her hair, she can come back to court.
Yes, Your Honor.
All right. Leave the Zoom. Miss Hollis. Miss India is it? India is it? Okay. Put her in the waiting room, Miss Young. All right. Now Phelan and Phelan and what's his name? Brianna Muniz. Phelan.
Yes, I'm here for Julian.
Start your
Jackson.
video. Start your video.
I'm at work. I can't start the video on my
Then
job.
you leave the Zoom.
Okay, well, can
leave
I
the
come
Zoom.
back in a second?
You can only come back once your case is being addressed, but
Okay, thank you.
leave the Zoom. Brianna Muniz.
Yes.
All right, start your video. Now, why are you sitting in the dark? We can't even see you.
My babies are sleeping.
All right, go into another room.
We gotta go, Your Honor, we going back to,
All right.
number 4.
Okay. Mr. Haddad, have you spoken to Mr. Binns?
No,
I have, Judge.
All right, and what is he understanding why it's simple battery?
Yes, Judge. We're ready
Okay.
to proceed.
So 25 CR 003908B to resume the plea hearing. Mr. Binns, how do you plead to one count of simple battery?
Yes,
How do you plead to one count of willful obstruction and giving false name?
yes,
Your sentence for simple battery is 12 months to serve 86 days, credit for time served 43 days, balance probated. You'll report to probation on Monday, the 21st. Does he have any holes?
Judge, I do not believe so. No, Judge.
Okay. You'll report to Fulton County Probation on Monday, July 21st before 3 p.m. While on probation, you will complete a 12-week anger management program. You must enroll within 60 days of being released. You will have no contact with Mallory Bellino. Stay away from the Shell gas station at 374 Cleveland Avenue in Southwest Atlanta. And within 60 days, you will enroll in a behavioral health evaluation and submit to all treatment that's required. Count 2, willful obstruction, is going to be 12 months probation concurrent with count 1, and you will complete 30 hours of community service at a minimum rate of 5 hours per month with any nonprofit agency that's not a church and not a school. And count 3, giving false information, is 12 months probation concurrent with count 1. Thank you.
Judge,
Yes, Mr. White?
I said thank you, Your Honor.
Oh, okay.
Number 29, Mr. Julian Jackson.
Ms. Tucker, how are we proceeding with Dorico Hudson?
Mr. Hudson is, going to be, reset till next week. Calendar.
All right, this is going to be reset to July 24th, 9 a.m. Thank you. Julian Jackson is accused of simple assault family violence from June 19th, 2025, case 25 CR 3454J. Mr. Jackson, you've been advised of your rights and your attorney is going to be Ms. Tucker. This is going to be a plea?
Yes.
Mr. Jackson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, Your Honor.
Thank you. Mr. Scaraco?
Yes, Judge, for the simple assault family violence, it is the same offer relayed for July 3rd's SAP calendar here. 12 months probation served, 90 days, credit for time served, 28 days. That is from June 20th of this year to present. Time has been adjusted. Balance probated. Have no further contact with Fallon Bellamy. Stay away from 1160 Hammond Drive in Sandy Springs. No firearms, and for him to enroll in and complete FFIB. We have spoken with Mr. Bellamy, and he stated he's in agreement with the plea. I believe he is on the Zoom, and we saw him, or at least his Zoom icon earlier. So stay with sound for Mr. Bellamy at this time. And we would ask the defense stipulate the factual basis, venue, and ID for purposes of the plea.
All right. Do you so stipulate, Ms. Tucker?
We do so stipulate for the purposes of the plea.
All right. Phelan Bellamy, if you have a moment from work, this is your time to unmute if you have anything to say and start your video. Phelan Bellamy. Sounds like he's back at work. Mr. Jackson, have you consumed any medicine or alcohol?
No, ma'am, Your Honor, I have not.
Have you understood what's going on in your case?
Yes, ma'am, Your Honor, I have.
And are you satisfied with your attorney?
Most definitely, yes, ma'am, Your Honor.
Do you understand that you have 17 more days to serve at the jail?
Yes, ma'am, Your Honor.
And if you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial. You will not be able to confront your accuser in a court of law, be able to present your arguments and defenses, and the state won't have to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am, Your Honor.
How do you plead to simple assault family violence?
Guilty.
Your sentence is going to be 12 months to serve 90 days, credit for time served 28 days, which means you have 17 more days to serve at the jail. After you've done with the additional jail time, you will report to Fulton County Probation within 48 hours of being released. While on probation, you will have no contact with Phelan Bellamy. You're to stay 200 yards away from him and not communicate with him in any way, form, or manner. You're to stay away from 1160 Hammond Drive in Sandy Springs, and you're also to not possess or own any firearms. Within 30 days of being released, you are to enroll in a domestic violence intervention program. This is a series of 26 classes, which you must complete without missing or skipping any of them, and they will be at your expense. You report to probation every month, and this will continue until the term of your probation is concluded. Thank you.
Thank you, Your Honor.
Position number 36. I'm sorry, yeah, position number 36. So come on.
Ms. Tucker, we ready to proceed? How we?
Yes, Your Honor, this will be a negotiated plea.
All right. This is Mikhail Wukil.
Yes, ma'am.
And case number is 25 CR 3759D. The defendant is accused of 2 counts of willful obstruction of an officer from July 2nd of this year. You've been advised of your rights, and your attorney is Ms. Tucker. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Scarell?
Thank you, Judge. For count 1, the willful obstruction, 12 months, served 32 days. Credit for time served 16 days. That is from July 2nd of this year to present. Balance probated, a $300 fine, and to complete an Op 21 law and decision-making course. On count 2, the other willful obstruction, 12 months probation concurrent with count 1 and a $300 fine. We ask the defense stipulate the factual basis, venue, and ID for purposes of the plea. That is all for the state.
Ms. Tucker?
We do so stipulate for the purposes of the plea. And Your Honor, we would like to request that the $300 fine be transferred to 40 hours of community service.
No objection from the state.
Now, is this a one-time $300 fine? It's concurrent for both charges?
These are, 2 separate $300 fines for each willful obstruction.
So, Ms. Tucker, is your client able to pay one of the fines and do?
We're asking for 40 hours on each count. So,
40
a total of 80 hours of community service, Your Honor.
All right. And is there a particular reason why he can't pay the fine?
Yes, he has been unemployed for the past 2 years. We were also going to request the initial months of probation fees be waived as well, so that he has the opportunity to find employment. He said that he did not want to commit to paying a fine that he knows he would be in violation of at this time, so he wants to be able to work it off with the court, Your Honor.
All right. On count 1, I'll amend it to 30 hours of community service. I'm just amending the fine to community service. On count 2, that will be a $300 fine, and he'll need to start paying in month 3 of probation. I'll waive his probation fees for July and August. And September 1st, September 1st, he'll need to start paying his probation fees and complete the 30 make sure that he completes the 30 hours community service and pay his $300 fine for the rest of the time. Hopefully he'll be employed by then. And once he has paid off the fine and done the community service, he'll be on non-reporting status.
I'm sorry, what position is this?
36. Would your client like to consider that?
Yes, Your Honor.
All right. Mr. Muwakil. I'm just going to call you Mikhail. Okay. Mr. Mikhail, have you consumed any medicine or alcohol?
No, ma'am, I have not.
And have you understood what I've recommended and what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to enter this plea, you would have to give up your right to a trial. You will not be able to go back to court to confront your accuser, challenge evidence that'll be brought against you, present your legal defenses and arguments, and the state won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am, I am.
How do you plead to 2 counts of willful obstruction of a law enforcement officer?
Guilty, Your Honor.
On count 1, it's going to be 12 months to serve 32 days, credit for time served 16 days, balance probated. Unless you have any other holds, you will report to probation on Monday, the 21st, before 3 p.m. For count 1, it will be 30 hours of voluntary community service, which you will do at a minimum rate of 5 hours per month with any nonprofit agency that's not a church and not a school. You will also enroll in the Op 21 program, and you will do so within 90 days of being released and complete that program satisfactorily. On count 2, it will be 12 months concurrent with count 1 with an additional penalty of a $300 fine. And this you will pay at a minimum rate of $30 beginning in month 3 of your probation. I will waive your probation fees for July and August, and you will start paying probation fees from September 1st onwards. Once you have completed the 30 hours of community service, the Op 21 class, and paid off the $300 fine, and you're up to date with your probation fees, your probation will then be non-reporting.
Thank you, Your Honor.
Thank you.
Number 8, Mr. Canty.
Judge, Mr. Canty wants a bond hearing, Judge.
Okay. Are you filing a waiver of arraignment?
Your Honor, I think, well, I will.
Okay, we'll hold off on that.
Right. Judge.
All right, Mr. Canty has been advised of his rights. He has opted for appointed counsel, who is Mr. Haddad. His case number is 25 CR 3754J. He's accused of theft by taking in 2 counts of willful obstruction. His bond was set on July 3rd, 2025 by Judge Morrow, and that was a
$1,500 surety bond, Your Honor.
okay, thank you. Is it 500 on each count?
Yes, Your Honor, that's correct.
Okay. And Miss Hardy, may I have his GCIC, please?
Yes, Your Honors. There are 33 arrests out of Georgia and Florida. Felony conviction in 2015 for robbery. There's an open case for theft by taking, 24 PI 001450. There's 3 misdemeanor convictions, but they're outside the last 10-year period.
Okay.
Nothing further.
How many cycles from Florida?
20.
20 cycles?
Yes.
All right. Yes, Mr. Haddad?
Your Honor, Mr. Canty is 37 years of age. He's been in custody, of course, since the date of arrest, July 2nd. I mean, it's a low bond, but he just cannot make bond, Judge. He has 2 children. When I asked him about employment, he does cleaning work, Judge. He also provided me an address, a local address where he can stay, Judge. That's essentially where we're at, Judge. He's clearly, obviously indigent, and I'm asking the court to consider releasing him through pretrial service. Judge.
All right. Ms. Falk?
Yes, Your Honor. So this case essentially involved the defendant going to the MARTA station and stealing tires off Mr. Victor Tran's bike on July 1st, 2025 at 855 East Paces Ferry Road Northeast, which is the Lennox station. The officers went through the video, the CCTV, saw the defendant take the tires from the bike and board a train. They sent a bolo out, and he was then later seen walking on 10th Street carrying 2 bike tires. At that time, he was placed under arrest. As you've heard, the defendant has cycles, 20 cycles out of Florida, and I believe close to, I think it's 14 cycles out of Georgia. He has a robust theft history. He also has a history of criminal trespass. I believe his last criminal trespass with us was August 21st of 2023, where he received, he pled guilty and received 12 months probation from Judge Morrow. I believe that's what factored into Judge Morrow's decision to set a $1,500 bond on this case, was based on his prior history, his lack of ties with the community, and the risk of reoffense. For that reason, we're asking the bond remain as set. It is a $1,500 bond. I understand that ability to pay is a factor, but risk of reoffense and the fact that he doesn't have sufficient ties to this community are also a factor, Your Honor. And we ask that the bond remain.
What? Anything else, Mr. Haddad?
No, Judge.
All right. Given Mr. Canty's significant criminal record history, his likelihood to reoffend, just based on his jailing record with Fulton County, he has been jailed in Fulton County in 2021, in 2022, in 2023, twice in 2023, in 2024, and now in 2025. He has made a consistent history of violating the laws and being booked at the Fulton County Jail. He poses a threat of reoffending, and the bond at the present time is highly reasonable in light of the ALF factors. So the bond modification is denied.
Understood, Judge. We'll go ahead and plead him not guilty.
Guilty, I go guilty.
Judge,
I'm tired of this law, man. This is the last time, man. I'm not last year because I schooled my kids. And I'm gonna need to go
Your
home.
Honor, my client has all along indicated he wishes to enter a plea, guilty plea. The issue, the hangup was the 60 days, which I understand the state's position, which is what we communicated with Paul.
I was going for 180 days.
The request, Judge, is that I spoke to my client repeatedly. I think he's indicating that he's willing to enter a guilty plea today if the court would honor the 60-day recommendation, Judge.
Which means he'll be in custody for how many more days, Ms. Folk?
14 more days, Judge.
14 more days?
Yes.
And then he'll be on probation?
That's
That is
correct.
correct, Your Honor.
I don't get that vibe from him. I know we're virtual, but I just don't get that vibe that he's agreeing to go on probation.
I don't honestly, Judge, that's not the issue. The issue was the jail time, really. But I've explained to him, I can't, you know, I mean,
He's already got a probation violation from May 2nd, 2024.
Mr. Canty, what do you want? You gonna plead guilty or no?
Well, I plead guilty.
I just answered the court's question, so.
Yes, sir. Yes.
Your Honor, we're ready to proceed if the court is willing to.
I'm tired of going. I'm tired of coming to jail.
Canty, stop.
We're tired of seeing you.
I know it.
Forget it. We're tired of seeing you.
Yes, ma'am.
We don't want you here.
No,
We do not want you here. I don't know why you keep thinking you're invited back to the jail. You're like a guest who keeps coming back. You know, like my aunt, I'm trying to kick her out of the house. So for pity's sake, don't keep telling us you're tired. We are tired of seeing you. But you keep getting in trouble with the law and keep going back to Marta.
Yes.
So don't sit there and say you're tired because I have zero pity for you. Zero. So be quiet.
Nobody
All right. Ms. Falk, would you like to allocute the terms for Mr. Canty?
Yes, Your Honor. 12 on the theft by taking, 12 months served 60 days, credit for time served 16 days from July 2nd, 2025 until today. Balance probated in anti-theft course, 40 hours of community service, no further contact with Victor Tran, stay away from all MARTA stations. Count 2 would be 60 days credit for time served, 16 days concurrent with count 1, and count 3 will be 60 days credit for time served, 16 days credit concurrent with count 1. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. We would like to sound for Mr. Victor Tran if he is here and would like to speak.
Victor Tran? Even he's tired of Mr. Canty. Okay. Ms. McLeod, do you need to speak to your client in courtroom 2?
Yes, Your Honor. Good morning.
Good
It's
morning.
Mr. Hollis. I do need to speak with him.
All right. I guess you call the jail or they'll call you. Okay.
It's easier for them to call me, Your Honor.
All right. Thank you, Ms. McLeod.
You're welcome.
Mr. Haddad, do you so stipulate to the factual basis, venue, and ID?
For stipulated, Judge, my only request if the court would waive the first 2 months of probation fees. And I would also, he does not have any other hold, so upon completion of the 14 additional days, he'll have to report to probation as required by the negotiating rule.
Oh, you know, he's not going to send me a Christmas card after he hears this. For the months of July, August, and September, I'm going to waive his probation fees. For the months beginning once he is released, he will report to probation twice a month until the end of this year, twice a month, because he is so fond of us that I want to make sure that he reports to probation twice a month until the end of December 2025, and then beginning January 1st, 2026, if he doesn't violate any other laws and he's compliant with probation, it may be modified to once a month.
Understood, Judge.
Is he in agreement with that?
Yes, ma'am, yes,
You
ma'am.
need to speak up. Look.
Yes, ma'am, I
I'm up here, I'm not on the floor.
just feel bad, ma'am, I just feel very bad, ma'am.
You should.
Yes, ma'am.
Like I said, I have no pity for this case. Now, Mr. Canty, raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, I do.
Have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with the services of Mr. Haddad?
Yes, ma'am, I am.
If you decide to plead guilty, you would have to give up your right to a trial in front of a judge or a jury. You will not be able to go back to court, confront your accusers, challenge the evidence brought against you, and present your legal defenses and arguments, and the state won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am, I am.
How do you plead to theft by taking and 2 counts of willful obstruction of an officer?
Guilty. I didn't put up a fight, man. They beat me up, man. I didn't.
All right, then we will reset your case for trial if you want to challenge it.
But they beat me up.
It's not, the charge, you didn't fight the officers, that's not the charge, you walked away. Just, if you're pleading guilty, resolving it today, you can.
Yes,
No, we do not.
I'm
So answer the court's questions.
I plead guilty.
You need to look at the screen.
No, I feel bad, man. I should have known.
You should look at the screen. Mr. Canty, I'm going to ask you one more time. And if I
I'm
cannot,
embarrassed, man. I'm embarrassed, man, because of who I am in my community.
you should be embarrassed, but look at the screen.
Go home, man.
Take responsibility for what you've done. Look at the screen. Mr. Canty, I've asked you if you're pleading guilty to 2 counts of willful obstruction and you responded, no, they beat me up, which means that you don't agree to pleading guilty. Now,
Guilty,
if your attorney just told me that the facts are correct, that you did willfully obstruct 2 law enforcement officers. Now, if that's not the case, then we can reset the case for trial. What I need to know from you is whether you are admitting that you are guilty of obstruction of law enforcement officer.
Yes, ma'am, I'm guilty.
I accept your guilty plea on the theft by taking for count 1 is 12 months to serve 60 days, credit for time served 16 days. He has 14 more days to serve at Fulton County Jail. Is that correct? 14?
It is, Judge.
Okay. After he served the 14 more days and he has no other holds, he will definitely report to Fulton County Probation, where he will report to Fulton County Probation twice a month until the end of December 2025. And if he's in full compliance with probation, it will then be modified to once a month beginning January 1st, 2026. I will waive his probation fees for July, August, and September. He would need to diligently look for employment and start paying his probation fees from October 1st, 2025 onwards. While on probation, he will complete an anti-theft class and he must enroll in that class before the end of this year and complete the class before the end of this year. He will do 40 hours of voluntary community work at any nonprofit agency at a minimum rate of 5 hours per month. He's to have no contact with Victor Tran, the owner of the bicycle, and he will stay away from all model property, which includes the buses, the trains, the bus stations, the train stations, until further order of the court, or if any suspensions have been lifted. For count 2, it will be 60 days, credit for time served 16 days, concurrent with count 1. And count 3, it will be 60 days, credit for time served 16 days, concurrent with count 1. Mr. Canty, don't give us a reason to never make a plea offer. Otherwise, you'll be serving jail time for the rest of the year. Do you understand? You've already violated Judge Morrow's sentence. don't do that with me.
Yes, ma'am.
Because like I said, no pity.
Okay.
Thank you.
Thank you, Judge.
Judge said he needs to complete the anti-theft course by when?
By December 31st, 2025.
Your Honor, we are, just so the court is aware, I'm ready to go over I know the court attempted earlier to go over the calendar, but we've all been one way or another stretched thin, so,
Well, we did need to.
but we're, whenever the court is.
I am so appreciative of that offer, Mr. Haddad, and I'll take it up. Oh,
And Your Honor, just a quick announcement, Mr. Cox, who was our bench warrant lift.
yeah.
He does wish to enter a plea. It was a time served plea with some, a condition of anger management and no further contact. He is interested in taking that plea today.
Okay, we'll take that up. Let's just go over the calendar and then take it up with Mr. Cox, and then we'll go with Ms. McLeod. Okay?
Yes, Your Honor.
Thank you. Position number 1 is a waiver of arraignment and further notice for trial. Position number 2 was null pros. Position number 3 was a plea. Position 4 was a plea. Position 5 is a null pros. Position 6, Brown Fay, and that is going to be.
I have a waiver of arraignment.
Okay, that's a waiver of arraignment and further notice jail jury. Position 7, Markel Bryan is a waiver of arraignment and further notice jail jury. Position number 6 was position number 8 was a plea. Position 9 was a plea. Position number 10 is going to be a plea. Position number 11 is also going to be a dismissal if we proceed with the plea. Position number 12, die is a waiver of arraignment and further notice jail jury. Position 5, and that was for position 13 and 14 as well. All further notice jail jury. Position 15, Llewellyn was a plea. 16 was a plea. 17, Goodman was released on July 11th. So these two cases, 17 and 18 are going to be further notice, and 18 as well, 19 as well, excuse me. 7.
Mainly gonna talk to you about her, please.
All right. And 20 as well. That's going to be, he was released, so that's going to be further notice.
And,
Let's move on to position 21. Hester, wasn't that a plea? No, Jakara Hester was released July 11th. And
okay.
so
Precious.
oh, this is Precious Hester, correct. Okay, I thought that was okay. Precious Hester was a not guilty and waiver of arraignment. Position number 23 is Ms. McLeod's. Position 24 was a plea. 25 was null prost. 26 Hudson is reset to July 24th, along with position 27 reset July 24th. Position 28 is reset July 24th. 29 Julian Jackson was a plea. Position 30 Javarius Johnson was a plea. Position 31 was dismissed. 32 Daniel Mack is reset to July 31st. Position 33 and 34 were pleas. 35 and 36 were pleas. 37 Newcomb was a plea, as well as 38. 39 was released on July 13th, so that's further notice. 40 Rodriguez, and that's, I guess, what are we doing?
We're gonna be reset to the 31st, Judge. Also need a Spanish interpreter, and I'll put that request as well with the litigation managers.
All right, position 40 is reset to July 31st SAP. Please make a note, we need a Spanish interpreter. Position 41, Villalobos.
He was released, Judge, this morning, last night.
Released July 16th. Tedrick Withers.
Oh, Judge, we need to reset him for next week, apparently.
We're going to reset to July 24th SAP. And Eric, and then I have 43 William Curtis. or Curtis Williams, who was released on July 11th, so that's further notice. And 45, Eric Wise was released on July 13th, so that's further notice. And then we have our bench warrant, Tavares Pittman. Ms. McLeod, are you ready to address your case?
I am, Your Honor.
All right.
And Your Honor, if I will say that concludes Mr. Sirocco's business. May he
he's
be
free to go.
excused
Thank
at
you.
this time?
Yep.
I'll handle the DV bench warrant calendar, ASG Sirocco.
Okay, Mr.
Thank you.
Sirocco, have a good day. Thank you.
Thank you, Deputy Fogg. Thank you, Judge. Have a good day, everyone.
You too. All right, and Ms. McLeod, what's your client's name again?
It is Mr. Hollis, Your Honor.
That's the Zarek Hollis case, Your Honor, position 23.
Thank you. There we go. Zarek Hollis is accused of theft by taking from July 2nd, 2025, case number 25CR3745H. Mr. Hollis, you've been advised of your rights. Your attorney is Ms. McLeod. Ms. McLeod, how are we proceeding?
I will be filing a waiver of arraignment, Your Honor, in this case, and my client would like to have a trial. He's also asked me to file a speedy trial demand, which I will be doing.
All right. Mr. Hollis, your attorney has entered a not guilty on your behalf, and your case will be further noticed for a trial. And understanding the state is on notice that defense counsel intends to file a speedy trial demand, so they will take the appropriate steps. Your case will be assigned to a division judge and be scheduled for trial. Thank you.
Thank you, Your Honor. May I be excused?
Yes, thank you. Ms. McLeod, do you have anything in our 11 a.m. calendar?
I don't. Is Mr. Rucker on today?
Bronstein.
Cedric Rucker?
Just making sure. No, I don't see Rucker on the calendar.
Okay, I don't believe I have anything.
All right then. Thank you so
No,
much.
I'm sorry. Was Mr. Grigsby?
Grigsby?
He's on for 11 a.m. That
Oh,
was the
Mr.
one you
Grigsby
asked
is
me to
on the
reset.
11 a.m.
Did
Yes,
we
ma'am.
add him?
Saturday, you asked me to reset him for this Thursday.
Oh, yeah, he's position 8. So is that your
Yes.
client?
He is my client, Your Honor.
All right, so we'll address that as soon as we start with that calendar. Thank you, Ms. McLeod.
Thank you, Your Honor.
Okay. So with regards to Mr. Hollis, that concludes his case. Thank you. All right, courtroom 2, Ms. Tucker, do you have any other matters?
Mr. Knox. I'm sorry, Mr. Cox.
Mr. Cox, he's taking a plea?
Yes.
Okay. This is positions 10 and 11. Mr. Corin Martinius Cox has got 2 matters with us, 24 CR 6861J, accused of battery from February 12th, 2024, and he's got a bench warrant from April 16th, 2025. Mr. Cox, you've been advised of your rights. Your attorney is Ms. Tucker. May I place you under oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Ms. Falk, what's the recommendation?
Yes, Your Honor. The state's recommendation on this case is 12 months serve. Believe the serve date is 96 days, credit for time served 48 days. That's from October 5th to November 5th, 2024 and July 2nd, 2025 until today. Balance probated, no further contact with Kenya Cheeks. 12 weeks of anger management. Stay away from the Valero gas station located at 5022 Old National Parkway in College Park, and no firearms. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. We would like to sound for Ms. Kenya Cheeks at this time, and the state will null pros the FTA as a part of this plea. That's all for the state.
All right. Mr. Cox, you can put your hand down, and Kenya Cheeks, if you're on Zoom, this is your time to unmute and start your video. And Ms. Tucker, do you stipulate to the factual basis, venue, and ID?
We do so stipulate for the purposes of the plea.
All right. In light of the fact that if the plea moves forward and the state dismisses the bench warrant or the FTA, you won't have to submit your proposed order. Okay? All right. Mr. Cox, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
No, ma'am. I have a question.
You can ask your attorney. She's sitting right next to you.
Will I be placed on probation?
Yes. That was the offer. Isn't that what was explained to you?
No.
So I was reading the email that she was recommending time served with anger management and a stay away.
Well, if he's required to do anger management, then he has to be on probation.
Okay.
That's how it works. If you do anger management, you have to be on probation, and he needs to stay away from the Valera gas station and no contact with Kanaya Cheeks. Once he's done with his anger management and his probation fees are up to date, I can consider non-reporting. Would you like to, if you want to mute the screen and go over those details with him? Okay, it's muted.
I'm sorry. I'm not.
Okay, hang on. Miss Tucker, are you done speaking with him?
Yes, Your Honor. So we've already entered a waiver on this case. After discussing further details with him, we're gonna continue on with having him on the trial calendar.
Okay, so please submit the order to vacate the bench warrant and dismiss the 25 FTA 001278. Make sure you mention that FTA case in the proposed order.
Yes, Your Honor.
Okay, and the case 24 CR 6861J is still open and active against Corinne Cox. Like I said, he must comply with the conditions of the bond order, which requires him to have no contact with what was the name again? Karine? Is it Karine?
Kanaya Cheeks.
Kanaya Cheeks, and stay away from the Valera gas station. All right, this case will be a further notice for trial pursuant to the waiver that will be filed by defense counsel.
Thank you.
Thank you. Okay, we have a bench warrant matter. Is Tavares Pittman on Zoom? Tavares Pittman. Okay. Mr. Paul Bartel, are you in courtroom 2?
Mr. Bartel went on, he went to visit somebody upstairs in that medical.
Okay. If Mr. Haddad or Ms. Tucker would like to call him or text him and let him know that otherwise we're waiting to address the competency calendar, and we're also waiting to address the bench warrant matter. He has a few more minutes to appear.
I think Mr. White may be handling the bench, the DV case if the person appears.
Okay. All right. We'll be in recess until he appears.
All right, thank you, Judge. May we be excused? I'll reach out to Mr. Bartels about the court waiting on him.
Definitely. Thank you, Mr. Haddad. Have a good day. You too, Ms. Tucker. Thank you.
Thank you.
All right, Mr. White, we'll just wait for your potential client, Tavares Pittman, to appear. He's not scheduled until 11 a.m. and we have maybe about 2 or 3 more minutes left. So, Ms. Greenhouse, take a break. Thank you.
Okay, thank you.
All right. I think Mr. Paul Bartel is not in courtroom 2 yet, so.
Right, Judge.
Oh, there he is.
Yeah,
Perfect.
good morning.
Okay.
If the court's ready to start, I can do that. I was gonna see Mr. Washington, Craig Washington up on the floor, but we can start right now if you want.
Well, my bench warrant case just appeared at the same time, so that will be about, I don't know. Mr. White, how many minutes would you need to speak with him? Mr. Pittman, take off your hat. You're in a courtroom. Okay.
Your Honor, 2 or 3 minutes or 5 at the most.
Okay. Mr. Bartel, how long would it take for you to confer with Mr. Washington?
About 5 to 10 minutes, Your Honor.
Okay, why don't you go ahead and start with Mr. Washington? And Mr. White, we're going to put you into a breakout room with Tavares Pittman. And then
Okay, thank you, Judge.
hopefully Mr. White will appear first, and then we can proceed with our competency calendar. Mr. Tavares, yeah, go ahead.
Mr. White, you do have the recommendation, yes? I just wanted to make sure you had it.
I do not have a recommendation.
Okay, I'll go ahead and forward that to you.
Thank you.
All right. Ms. Young, if you will send a message to Mr. Pittman and Mr. Tom White. Oh, they're already in a breakup. Excellent. Okay, folks, we'll be in a brief recess again until one of them reappears. Thank you. All right, Mr. White. You should climb.
Yes,
From
so
the breakout?
should be coming back in.
Miss Young, is he still in the breakout room? Miss Chanel Young or Miss Casey Strong, do you see Tavares Pittman in the breakout room?
I'll check, Your Honor.
Okay, thanks. Any luck?
I just requested, he should be coming back in, Your Honor.
Okay. All right.
There he
Mr.
is.
Pittman.
There he is.
You.
He was still there.
All right, please unmute. Mr. Pittman, please unmute. This is case 23 CR 0065098, State versus Tavares Pittman, charged with simple battery family violence involving one Kenedria Whitfield from September 27, 2023. Mr. Pittman, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Tom White. This was a failure to appear before Judge J. Roth on July 2nd, 2025 for a final plea. His bond was forfeited, and there is a bond forfeiture hearing scheduled later this year. Yes, Mr. White?
Your Honor, we're just asking that the bench warrant be set aside at this time. He never received notice. We're not sure exactly why that happened. We do have an address on file. Or an address that we're ready to give the court if it's not the same one that's on file. He said he did change his address with the court last year at some time. He does have 2 jobs. The reason he found out about this is airport just applied for a job at the airport and was hired, but they did a background check showing that he had this outstanding warrant. So he immediately got in touch with the court. I don't think he's any kind of a flight risk. He lives with his mother, and that address is 10227 Sunny Drive in Covington, Georgia, 30014. We just asked you to set aside the bench warrant at this time. I believe this is the first time he's missed court on this case as well.
Let me clarify. That was 10227 Sunny, SUNNY Drive in Covington, Georgia. What was that zip code?
30014.
And is there a unit number or?
He did not give me one.
Mr. Pittman, what's the complete address?
Oh, it's a house.
Okay. And when did you move there?
In 2023.
I apologize, Judge, before we proceed. So he did this on July the 10th when he came in to reset and he wrote the 500 Northside Circle. That's not it? Because that's the address.
What we're going to try to figure out. He gave us a completely different address.
I'm sorry, this is my mailing address, the 500 Northside Drive. But I don't live there. I live in Covington, Georgia.
And did you check your mail for 500 Northside Circle?
I just recently just started getting mail here.
Mr. White, I'm not certain what Mr. Pittman's trying to say. He said his mail is received at one location and he lives in another location. And
I think what he's now is going forward, he's receiving his mail at the address that I just gave the court.
I know, but he didn't check his mail at Northside Drive because he doesn't live there.
He did not say he didn't check it.
He just said it.
No, it's been checked, but
Nobody
it- I just started receiving mail at 500 Northside Circle.
So what address should be in the system? I'm sorry, that we're supposed to be sending a notice to?
The address in Covington, the 10227 Sunny
So
Drive.
not the address that you wrote on the paperwork when you came in to reset your case, is what you're saying?
No, ma'am, it's not that one. And like I do apologize for the inconvenience. I wasn't trying to.
It's not an inconvenience to us, sir. If you give us the wrong address, the only inconvenience is you go to jail.
Yes, ma'am.
So it's not an inconvenience to us, it's an inconvenience to you.
Yes, ma'am.
You messed up by not giving us a straight answer. So, Mr. White, what is your client's current living address?
The address I provided before, the Covington address.
Okay, Ms. Strong, according to defense counsel and the defendant, it is the 10227 Sunny Drive in Covington, Georgia. I forgot the zip. I think it's
30014.
30014. Okay. All right, Ms. Falk.
Nothing, Your Honor. The defendant, this is his second arrest. His first case was dismissed back in 2016. He has no FTAs, nothing else. So the state will just defer to the court on this.
Did y'all dismiss the transfer from Superior Court?
We did back in 2017.
Just wanted to be sure. Okay. I will set aside this bench warrant and reinstate his bond. And his next court date is going to be set by Judge Roth's division. He is still required to have no contact with Kendria Whitfield and stay away from the 505 Fulton Street in Southwest Atlanta.
Thank you, Judge.
All right, Mr. Pittman. See you in court.
Thank you.
Mhm. All right, Mr. White, thank you so much. You're free to go.
Thank you, Judge.
All right, Mr. Bartel. Okay, let's see if we can release some folks from the Zoom. Miss Chanel Young, can you stop the YouTube, please, the live stream?